Ready, start. The charges involved in the extension of services apart from payment of cost to the merchant establishment and repayment to the issuing bank by the card holder are within bracket the MD are retained by the acquiring bank bracket close. The charged paid by the acquiring bank and issuing bank to the card associations semicolon and the interchange fee retained by the issuing bank full stop. I find that the interchange fees and for facilitating the purchase using the card and not for lending the money for the purchase as claimed by the assessee full stop. The credit card is issued to facilitate credit purchase and in due course the credit extended is received back with appropriate interests from the cardholder in line with the contractual agreement the issuing bank has with the cardholder, while the interchange fee is the consideration that accrues to the issuing bank for verifying, facilitating and extending the purchase value in line with the contractual agreement the issuing bank semicolon has with the card association and taking the risk for collection of amounts from the cardholder full stop. In view of the above, I find that the interchange fee is a consideration received as a suit of contractual agreements with the card associations to facilitate purchase of goods or services full stop. Therefore, I find that the argument that there is no service or service receiver dash provider relationship is not available or the fee is not a consideration as it is not negotiated upon, do not hold merits full stop. As per section 67 of the act, the gross value of the service is the amount received for provision of service full stop. It is nowhere stipulated in law that the consideration must be negotiable full stop. However, issuing bank while entering into agreement with the card association agrees to abide by the rates and charges and therefore the argument that the consideration is not negotiated is not factual as by agreeing to the rates, they are negotiated full stop. The definition of credit card services as it existed up to 36 2012, clearly states that the services provided the card associations to the issuing bank is a taxable service and effective from 1/7/2012, activity provided by one person to another for a consideration is a service full stop. Still further, the commissioner went on to find, in regard to the question, whether there was suppression by the respondent relating to non-payment of service tax on interchange fee full stop. It was found that the respondent had received interchange fee full stop. It was further found that when the legal provision is clear and explicit, the act of not paying service tax revealed a positive act on the part of the respondent full stop, even if they were under the belief that the charges are not liable to service tax, they should have approached the department with the details so that the department could have examined the correctness of the claim full stop. With the introduction of self-assessment, there being no ambiguity in the provisions of the statute, the onus of making proper assessment rests with the assessee under section 70 full stop. The period of limitation would commence from the date of the knowledge of the department full stop. After the unraveling of the different dimensions of a credit card transaction made exigible to service tax expressly, he would contend that there was no scope for the contention of the respondent that there was no service rendered by it full stop, both for the period prior to 1/7/2012 and for the period thereafter, it was crystal clear that the respondent was rendering and would continue to render service within the meaning of the act, and it is impossible to contend that the interchange fee is not liable to be taxed in the hands of the respondent full stop.